that would be encompassed by August the 25th.
Well, that's true. And I think the thrust of the testimony was that they did play the role of aggrieved sons. They did lie to the relatives and others, and the specific lies they made were brought before the jury in many different forms. There was no claim of Lyle Menendez while testifying that he was not playing the role of bereaved son or that he was doing something other than what the prosecution claimed he was doing. And now this evidence is brought in to give the jury a final dose of false statements on an issue that really wasn't disputed by the defense.
Right. Well, as far as this August 25th conversation in the limousine, it does appear to be rebuttal to the type of evidence that's been introduced by the defense relating to the defendant's demeanor and behavior. And there has been no showing that the prosecution knew of this prior to the date of the interview of November the 21st, 1993. And no showing that the prosecution deliberately failed to obtain this information until this stage of the proceedings. And therefore, I find it's proper rebuttal evidence, and there is no impropriety in it being used at this time under these circumstances. It's being offered only as to the defendant Lyle Menendez. As far as the related conversation, we'll get to that a little later on. If you could, first of all, is it the people's recollection as well that this was something that you had offered and the court ruled upon prior to the trial?
Your Honor, it is definitely in the motion I filed on March the 15th. But my recollection is that when we finally got to going through the motion item by item, that I said that we weren't going to offer her in our case in chief. So I don't recall that there has been a ruling. And I'd like to, in fact, I have a log here I'm checking right now to try to figure out when we finally did that with the motion.
Okay, well, you can find that. There were many issues that the court indicated it would not rule upon prior to trial. There was many matters that the parties sought rulings on as far as little bits and pieces of evidence, testimony of each and every witness that the court did not feel would be appropriate to rule upon prior to the trial, that these are matters normally handled during the trial. And I don't recall specifically ruling upon this one. If you can find it in the record, you can certainly identify that. And if there has been reliance upon it by the defense, then we can discuss it further.
I think the point here with respect to that is, I think the court did rule on it, first of all, generically.
Fine.
Saying that consciousness of guilt.
I mean, in general, not that specific statement.
I don't know if the court said this specific statement, but my recollection of the procedure was that people offered various false statements on a consciousness of guilt theory. We took the position that was not relevant because identity was not disputed. The court rejected that position, which left the prosecution free to come forward with any false statements they had. They, at that point, said, this particular statement we're not going to offer. But regardless of whether
they actually said that prior to trial, that we will not offer this statement?
Yes. Regardless of whether the court ruled or not, the fact that they identified that in their motion in limine as relevant to their case in chief, I think illustrates that this is improper rebuttal, that they themselves knew at that point that it was something that should have been offered in their case in chief. And as a matter of tactics, they held it back and it wasn't held back because the court ruled it inadmissible. That I do know. The court never said this statement may be admissible in rebuttal, but it's not admissible now. At best, the court may have not specifically referred to the statement, but they never pressed for a ruling, and they themselves came forward with a statement as an item of evidence admissible in their case in chief.
Okay, as I said, I don't recall ruling on that specific statement related by Ms. Eisenberg, one way or the other. That's the first issue. Now the defense's position is that it was a ruling in general about any statement of the defendants that were made falsely, that the defense position is that each and every false statement of the defendants had to be introduced by the people in their case in chief, even though the defendants have since testified in their own defense and your position is that people cannot offer anything else in rebuttal to their testimony in regards to other false statements they made. Is that your position?
No, I think the court has stated the position too broadly. Our position is when the people themselves come forward with a particular piece of evidence and identify it as admissible in their case in chief, and without any restriction by the court, they hold that evidence back, that particular piece of evidence is not proper rebuttal under the rules, which say that they cannot hold back pieces of incriminating statements and then introduce them late in the trial on a theory that they could have used during their case in chief. And in fact, they did use for other statements. Not that each and every statement that they could discover or that was not in contemplation of their case in chief could never be admissible in rebuttal. I think that's too broad the way the court framed it.
Well, as I understood from an offer yesterday or earlier when this was discussed, the people, and I know the defense position was that this was their real purpose in bringing it out, and why you objected to it was that it somehow fit in with some other evidence that's been received during the defense case relating to taking a shower or something of that nature after the killing of the parents. And that's really why the prosecution is seeking to introduce it now. If that's true, then haven't they now focused on a reason to introduce it that you've articulated that they didn't have prior to the trial?
I was the one who made that argument, Your Honor. It had to do, we were talking about Judalon Smith testified that when she said something about them taking a shower, it was pure speculation on her part because she figured out if it had been so bloody, they would have gotten blood on them. And so she told the police. In the course of her telling the police this theory, she's telling them she's speculating. So
Well, also bear in mind,
stretching it.
Well, you're the one who offered it as a position that you thought was why
We didn't
people were
offer
offering.
it for the truth. We offered to show she was speculating.
Yeah. Okay, but let me go one step further in response to Mr. Burt or inquiry of Mr. Burt. The people obviously are now in a different position, as is the defense, now that they've heard the defendant's testimony.
Yes.
They did not know what the defendant's testimony was until they testified. So aren't they entitled to introduce things that could impeach their testimony that they didn't want to introduce before?
On the theory that this statement shows that he, in fact, was taking a shower after the homicide?
That either that or that he lied about it, an additional lie that or a contradiction to his testimony in the trial here. This is a prior statement of his. Inconsistent statement can be used for whatever purpose the jury wants to use it.
I have trouble reconciling the lying theory with all the evidence they did put in under consciousness of guilt, because they articulated for the court that although identity was an issue, state of mind was, and false statements such as the September 17th statement, the August 21st statement, and several other statements, the mafia statements, were all relevant on a consciousness of guilt lying theory. That was their theory going into the case in chief. The new theory is I would concede to the court different. That is that this statement now becomes relevant because it proves that they took a shower after the crime. If that's what the statement shows, then that might be a proper rebuttal theory. The problem I have with that is that in the interview with Miss Eisenberg, Detective Zoller, in the last pages of the report, says that Lyle said, I was in the shower. I don't know why I didn't hear anything. I.O., meaning Zoller, asked Eisenberg what time Lyle was referring to being in the shower. She said during the murder. So I think the statement is clear that she is saying that he was in the shower during the murder. And that then is relevant only to a consciousness of guilt falsehood theory. I don't see how that statement is probative of showing that he took a shower after the killing.
All right, what is the people's response to this colloquy, if any?
Well, Your Honor, I'd just like to point out that on March 15th, when we filed the motion to admit the evidence, it was one of the first motions filed, and we still had pending before the court at 1538.5, which might have excluded Dr. Oziel altogether. If that had happened, the people would have had to resort to other means to prove identity. In the meantime, the defense conceded identity and tried the case on other theories. So I'd just like to point out, because it was in the motion on March the 15th, there were many issues left to be resolved as to how the case is going to be tried. As to this particular statement, it's the people's theory that shortly after the murders that the defendants did return to the guest house. Officer Butkus testified, I believe, that the guest house was open and the lights were on, the front door was open. And and Dr. Burgess testified that whoever had done the killings would have had blood all over them. And Sergeant Edmonds testified that there was nothing remarkable or noticeable about the defendants' clothes or their persons when he interviewed them. So it's the people's theory that when Lyle Menendez said he took a shower, he's correct. It's just he wasn't going to tell Ms. Eisenberg he took a shower after he killed his parents, certainly. And that this is a statement, is similar to the statement of there was smoke in the room when we came home. We know now that the smoke was when they did the crime, but the smoke is something that stuck with them that indicates that they were the ones that did the crime. When Mr. Menendez talks about the shower, it's the people's, I intend to argue that in fact he did take a shower, that they immediately retreated to the guest house, and that this was an alibi that was going to be offered in case they got caught in the guest house when the police arrived, and they could say that, well, we were out here, we didn't hear anything, and it's being offered for that particular purpose, especially in light of the fact that the defendants testified that after the murders they came up with this idea that they had to get rid of evidence and they had to travel all these different ways, that this is in fact what happened and not what the defendants said what happened.
Okay, does someone have the original report that Detective Zoller obtained?
And that's the
Or I have it, I'm sure, in the exhibit that was attached to the motion that was filed by the prosecution.
Yes.
Your Honor, what's the page, do you describe the report now? What is the typewritten page number at the bottom of the report? Does it have one?
268.
268?
Yeah.
Thank you.
Your Honor, am I to infer from that they are trying to offer the shower statement now against Eric Menendez? Perhaps Mr. Kuriyama will argue they're taking the shower together.
Well, number
That's
one,
quite
this is
plausible.
a statement attributed to the defendant, Lyle Menendez, so it's only being offered as to him, I suppose. Is that right?
Yes, Your Honor.
So what is question 3 exactly? See for yourself. Just read what's on your ballot. Question 3 gives all Nevada voters the right to participate in an open primary to pick candidates for the general election, then ensures that the winner gets a majority in November. That's it. Clear, simple, easy. Question 3 takes power away from political elites and gives it to you. Learn more about all the details. Vote yes on question 3.
Judges, the court can see also can read on that statement, the genesis for the statement was not really Ms. Eisenberg, but it was the investigator from Live Entertainment who calls Eisenberg up and suggests to her that he had heard certain information. So we have the collateral issue of the reliability of what she overheard. And I also, in that regard, on the unreliability aspect of this note for the court, that in her notes, or the prosecution's notes of this statement, she says that it was a throwaway conversation, thought she'd misunderstood. So the prosecution is really seeking to get a lot of speculative mileage, I think, out of the statement, which on its face refers to being in the shower at the time of the murder. And if it's admitted, there are impeachment issues which would need to get explored, both in terms of the people who interviewed her prior to and after taking the statement, as well as the Live Entertainment investigator.
Well, first of all, it would help the court in evaluating this, whether or not this specific conversation was in fact ruled upon by the court. As I said, my recollection, it was not. Your recollection was it was, but if it wasn't, your position is that generically any such evidence should have been offered. I don't agree with that. So first, I would like to see if the defense has relied upon a ruling of the court that this was going to be offered by the prosecution. And if not, then the court's view is that this is proper impeachment of the defendant, Lyle Menendez. And, well, just do it. Don't tell me how you find it. Just find it if there is something there. I really don't want to consume any more time about how you find it. What else is there in relationship to Ms. Eisenberg's testimony?
I just, on page 20, there's a statement by Lyle Menendez, an opinion, a conclusion about, are you offering this against Eric Menendez?
Let me get there. No, it's not offered against Eric Menendez.
Our objections would be the same as the two prior statements
Oh,
or
it's
the
even
first
worse.
statement we discussed, Your Honor.
It's even worse. What is it?
And what is,
Relevancy, improper rebuttal.
all right, again, was this known by the prosecution beforehand?
No, Your Honor.
It's in the notes of November the 21st. What is it that is being offered to prove that? The
Well,
statement is in relationship to a conversation about Eric Menendez doing or speaking at a service or performing a eulogy.
yes,
And the quote of Lyle Menendez was, "Don't worry, my brother's a good actor."
correct.
What is it being offered for?
It's being offered because of the defense posture that the grief and emotion which was exhibited to Sergeant Edmonds on the night of the morning of the 21st was genuine. And I believe that Lyle Menendez himself testified that he was worried about whether or not his brother was going to be able to make it through the story with Sergeant Edmonds, and that Sergeant, and in fact, he sent his brother in first, and if his brother didn't make it through, they were supposed to signal each other. And I think this is corroboration that he, in fact, believes that his brother is a good actor and was able to make it through that particular time. And I think it also goes to dispute the notion that this is genuine grief felt by these defendants, but in fact is something that is an act.
Yes.
It's an ambiguous statement. He could just as easily be saying, my brother feels genuine grief and is good at hiding his genuine grief.
Yeah, I don't see how this really proves or disproves anything. It really is ambiguous what it means. So the objection is sustained under Section 352 of the Evidence Code. I don't really see it proves anything.
Now, Your Honor, on page 21, there's an addendum at the top. It says, and I haven't highlighted it, but I would like to use it. It says she'd pick Eric up at high school at Calabasas when Kitty back east, before she, being Kitty, moved here. That's supposed to be here. Ms. Eisenberg indicated that Jose and Eric Menendez came to California and set up set up house prior to Mrs. Menendez moving out permanently, but that Mrs. Menendez would commute back and forth, and that during this time, Marzie Eisenberg often picked Eric Menendez up from high school because his mother was unavailable because she was still commuting between the two homes. And it says here, Jose did sometimes too, meaning he also picked up Eric from high school. The relevancy of this is I believe that Eric Menendez indicated that in regards to the child molesting, that when he first got to California, that it had abated. And it would be the people's position that if, in fact, Mr. Menendez and Eric were living alone in California for a period of time, that it would be inconsistent with the theory that he is a child molester, that he'd be alone with his son and not take advantage of the fact that he was alone. So that's the offer, and we would like to now use this. And in front of both juries, simply because Eric Menendez testified to the child molesting in front of both juries.
Well, Your Honor, the problem with this is that Ms. Eisenberg is completely wrong. We called 20 witnesses to prove this, but we have the family moved, the moving van came, Mrs. Menendez came, she met Karen Farrell, who's their other witness. She called her, said they were moving out. They talked about getting Eric into Calabasas High School.
Well, let me stop for a second. I just don't see that this is proper rebuttal. It doesn't rebut anything. The argument of the people is one that doesn't really hold water. I don't see how it proves or disproves anything. It's not really proper rebuttal. It doesn't refute anything. So the offer is, the objection is sustained. All right, what is, any objections to anything else on page 21?
Yes. There's an objection about the statement by Kitty Menendez that Kitty Menendez, was up all night with Lyle till 6 or in the morning. She was exhausted. This sounds like pure hearsay, statement of past acts or belief.
Your Honor, this information came in through Dr. Cox, I believe, or One of the experts testified, and you know what? It may have been Dr. Conti, who slipped in that there was evidence during the week that Kitty had been up all night on the phone. I specifically recall that because I was startled that he had mentioned that. But more importantly, this is a statement of Mrs. Menendez's state of mind at a time period which is crucial in this case.
When is the time? I don't understand.
Well, I'm sorry, Your Honor. I think because and the reason I made this note is because it's in the Kroll report, which I don't think the court has.
What is a Kroll report?
Okay, Kroll was an investigative firm hired by Life to investigate the homicides. And what it refers to is the Wednesday or Thursday of that week. That would be the 16th or 17th of August. And that is when, that is the night, it was either the night of the 16th or the night of the 17th that Ms. Eisenberg was referring to. It's also in the one of the police reports that the defense has, I think. Let me see.
Well, what does this say? Conversation by Eisenberg
With Mrs. Menendez.
Mrs. Menendez on Tuesday.
Okay, Your Honor, from the police report, which.
Two different dates, it depends. The police report says one date, the Kroll report says
Okay,
another.
yes, the police report indicates, the police report from the 22nd of August. Okay, that was when they talked to her, 22nd of August of
Right.
89. Second page, Marzi recalled that on August the 16th or 17th, while Jose was on a business trip, she received a phone call from Kitty, who was complaining about being kept up all night the night before talking to Lyle on the phone. It was her impression that there was some type of family problem. So this, I know the court doesn't have that report, but the defense does, and this is a reference to that particular conversation.
And what date was this supposedly?
August 16th or 17th, which would have been the Wednesday or Thursday of that week.
And what is it that you're offering it to prove?
We're offering it to prove that, in fact, she did have a problem with her sons, but it is not any of the problems which have been described by the defendants in their testimony. I believe that the testimony is that on August the 15th, the hairpiece was ripped from Lyle's head, that he then went and spent, I think that was the first night he spent with his brother in the guest house. And I believe I even asked him if he talked to his mother on the phone. I can't recall if I did, but this contradicts that and indicates that there was a family problem during that week, but that the family problem was something that was not, is not anything that's been described by either of the defendants during the week between the time period of August 15th through the 20th.
All right, and there has been mumbled the defense objection that it's hearsay.
Yes, Your Honor. And once again, the people are offering statements of Mrs. Menendez, which are to show her then existing state of mind. And
What is the state of mind?
her state of mind is that she had just been up all night. It's also offered under 1240 as an excited utterance. And I think that considering the amount of hearsay that has been admitted in order to show states of minds of the victims at various times, that this is well within the bounds of those kinds of statements and should be admitted to show that she, in fact, was of the state of mind that she was exhausted because she had been up all night with Lyle.
The statement that she had been up all night is not state of mind. It's a fact that is being offered to prove that she was up all night, and that can't be state of mind inception.
It does sound like it is hearsay and offered to prove that fact that she was up all night. It does sound like hearsay to me.
Well, Your Honor, if I'm able to find the reference in Dr. Conti's testimony, which I believe.
I think I can clarify that. I believe what he was talking about was the calls between Mrs. Menendez and Mr. Menendez at the grandmother's house in New York. I think that's the reference to, the only reference to phone calls that I can remember. So I think that's the reference.
Well, obviously, if there's some other reference that you feel that ties into this in some way, I'll certainly consider it. But from what you're presenting to the court, it sounds like classic hearsay and would not be admissible. What else is there objections to on page 21, if anything?
Well, the next paragraph, the fact that although she doesn't remember the last time that she saw Mr. Menendez, which is what that refers to, Your Honor, nothing was out of the ordinary. I mean, she either remembers something or she doesn't remember something. I just think that's unreliable.
Well, when did you last see him? Is there some
She
information?
saw him Friday, the 18th of August, after he got back from his business trip. And if you go down to the second from the bottom, where it says Jose transparent, obvious to Marzi if he was upset, that's in reference to this particular thing. In other words, he was not someone who was consistently in a good mood at work. She originally told the parole investigators that he was in a very good mood that day. I questioned her about it. She said she has no present recollection of that fact. She does recall that there was nothing out of the ordinary about him and that he was sometimes in a bad mood, and that she would have noticed that because he was not one who hid that, and that she recalls that there was nothing very good nor very bad about his demeanor that day.
Well, she certainly can be asked questions regarding observations she made of his demeanor on that particular day. And if she can describe it, she can. If she cannot, then she cannot.
She can't say she would have if she could have, because
Well, we'll just have to wait. That's something that can be asked and question and answer and objection if there is one.
the next thing I object to, Your Honor, is her conclusionary language that at the end, Eric was becoming the star, the glory being transferred to Eric. Clearly, she doesn't have personal knowledge. This is rumor, hearsay.
As well as the
Conclusion.
on behalf of Lyle Menendez.
Yeah, Lyle always something.
What is the
wrong.
people's offer there?
Your Honor, as far as the Lyle always being something wrong, we would withdraw that. As far as the, I'd have to ask her further questions about this. It's my impression that this is because of the way the parents spoke of Eric.
All right.
Still a
And
conclusion.
if in fact the parents spoke of Eric in terms that were favorable, I would offer those to contradict the notion of the heir and the spare, which has been promulgated by the defense, that Eric was in fact just this throwaway child.
All right, you'll have to discuss it with a witness, and if there is some specific conversations, you can disclose that to the defense.
I'll have Detective Zoller contact her then.
Yeah.
Anything else? In regards to her testimony, any other
I think
objections?
we've gone through everything.
22, I think we've covered that.
We've covered everything, Judge.
All right, then that completes her testimony. There, other than the research relating to the defense objection to a particular offer of proof by the prosecution, everything has been ruled upon, other than any specific questions and answers of the witness.
Just one question, Your Honor. I don't think it was specified, but I think the letter issue, Mrs. Bozanich, is only being offered as to Lyle.
I'm sorry, I was talking to Ms. Lansing.
I wanted to just inquire
What?
the issue about the letter. The court's, it's still up in the air about
Which letter?
the letter that Ms. Eisenberg claims she saw that Lyle might have read.
Right. Well, we need more information now. We don't really know specifically what she's going to say.
I just
Yeah,
wonder who it's
and-
offered against.
Well, it's only against Lyle Menendez.
That's all I wanted to know.
That's what the people's position was, wasn't
It wasn't clear.
I think so, Your Honor.
it? That it was in his file, and he supposedly referred to it in his remarks.
I didn't write down, the reason I think it's relevant as to both defendants is because I think that there's been a joint defense that the father, to portray the father in very unflattering terms vis-a-vis his children. And that was done through the testimony of Eric and Lyle Menendez in front of both juries. And I think that this would dispute that particular notion. And even though it only goes to Lyle Menendez is one, I mean, he did testify in front of both juries. So I don't think this should be limited, assuming we can lay the foundation. I don't think it should be limited to just one defendant.
What's wrong with this simplifying what the defense? This isn't that simple a defense. The Eric Menendez testified he always thought his father loved Lyle. This doesn't contradict. I mean, we were talking about two different people having different relationships. Even on the tape of 1211, Lyle Menendez is saying, or Eric Menendez is saying, there too we related very
All
differently.
right, what I would like to do is know, as I said, specifically what it is that occurred, whether the defendant, according to the witness, quoted from the letter or just said things that rang a bell in her mind, things that she read in a letter, number one. Number two, as to any specifics, if she has any recollection of specifics
All right, yeah.
of what was said, so that we can at least have some basis for discussing it further. Right. Anything else in relationship to testimony of witnesses?
Still on hold for the shot.
the agreement not to object to the calling of defense experts on the grounds of improper server rebuttal.
Yes.
That's in volume 124 at pages 20,891 to 3.
And what does it say?
It says, it refers to defense experts and in the plural, and also refers later on to Doctors Maloney and Vickery. There's 3 different pages that it's
Okay.
discussed, but there's clearly contemplated that there would be 2 experts called.
All right, my recollection, it was specifically related to Vickery in relationship to whether the people were going to call a witness. That's why the defense was up in the air as to whether they wanted to call Vickery during their case in chief and wait until after the people had put on their rebuttal before they decided to. And my recollection was Vickery, but I'll review it. You have the actual transcript there, or just notes or what?
I have it on my computer and pulled it up. I have it right here for the court.
No, I'll certainly
Can
look
you
at
put
it.
it on the bench, the judge can see?
And as far as the court's direction to counsel, regardless of that, I still want an offer of proof as to what they would say as to why it's not cumulative.
We should plan to have.
Anything else relating to testimony of witnesses? And again, just because you didn't call somebody in your case in chief, you should still use some good judgment as to whether or not this is really something that should be introduced at this stage of the trial. Don't just call a witness because you have thought more about it and would like to put on some more evidence. That's not really the basis for making these decisions. All right.
You're referring to the experts, that's not the issue. I always intended to call Dr. Vick. I'm still not sure about Dr. Maloney.
Well,
So, I mean,
why don't you make up your mind on him so then we don't have to worry about him if you're not going to call him.
I'm
So,
going to meet with him on Sunday. But the point is, I always knew I wanted to call Dr. Vickery because there were things he could testify to that the others couldn't.
all right. Well, you'll have to isolate what those are because, again, we've heard extensive testimony on behalf of each defendant or by experts. And if there's any duplication there, especially in light of the fact the prosecution hasn't offered any other contrary evidence, I want to hear what it is before we have that testimony offered to the juries,
It's only one jury. It's not going to both juries.
Your Honor,
regardless.
it's the defense position that the people are not entitled to rebuttal witness statements because it's not contemplated by 115. And I'd just like to point out that it appears to me that the duty to, the idea is always that the people have to provide, would have to provide sir rebuttal after their rebuttal. So it seems to me like there's always a continuation that as soon as the people find out they have evidence to contradict that which the defense presents in their rebuttal, then the people would have the further obligation if they're going to put on more witnesses to provide that. So it's a continuing obligation. And so I think the argument that we're not entitled to know who these people are or to know anything about what they're going to say fails, because just because we may choose not to call in any further witnesses after they put on the rebuttal doesn't mean that we couldn't. And therefore, we always have this continuing obligation. And I don't know what case or they're citing that indicates that we are not entitled to the rebuttal.
The problem is that they're not entitled to it now because they haven't finished their rebuttal and
Yeah.
we don't want them to tip their witnesses. That's all.
That's really what we're talking about, that why should they be giving you their witnesses before you finish
Finished yours.
your case, so that then you'll be putting on witnesses to refute their rebuttal before they get a chance to put it on.
Does that mean we didn't have to give them our rebuttal witnesses when we
No, once you've made a
It's
decision that you're going to
argument.
call a witness, then you would. But at some point, we have to,
But
call
we,
a halt to that.
I know, but I mean, they were able to anticipate our rebuttal witnesses because we gave them their names and the statements all throughout the defense case. And in many cases, they were able.
Well, you know most of these witnesses that they're calling. So
Well,
But is Azaga required that, Your Honor, in its footnote, or it would be constitutionally not fully reciprocal?
Okay,
That's really why.
really, as I understand it, you've been provided basically with who these witnesses are
Well,
that they're calling.
I have no idea who these character witnesses are because they're called character witnesses for Brian Anderson. I mean, who's that?
When Brian is finished testifying, then we will tell you who it is.
All right, well, then who's the character witness for Jamie Plazarczyk? Because she is gone.
That's a witness we haven't determined for sure to call. The witness is
Okay.
deciding whether or not he will or she will
All
testify.
right, then you make that decision by Monday and turn it over to the prosecution
Oh,
on
it will be
Monday.
made. It will be made by
Make
Monday.
it by Monday so that we don't have any delays and the prosecution has a chance to research the matter.
It could also be volume 49.
All right, let's turn to the exhibits then. There was a new supplemental list provided to the court today.
This is my list from my notes. I haven't corrected it for accuracy. I've been trying to take good notes.
What is, as far as what's been given to me, it's a list of November the 14th with the attachment prepared for today. Those matters highlighted, as I said, I would like you to indicate those things that are really subject to further litigation rather than just preserving the record.
Your Honor, we talked about this at lunch. We really think the most expeditious way to do this is to just do it. Start at 1 and we will just tell you. This is just an objection being made because we previously.
I don't want you to say that. I just want you to identify those things that are for the record. I don't want you to tell me all those things that,
That's what I mean.
no, I want you to tell me things that are not just for the record. Otherwise, we can be here all, forever. So I do have a list and it's highlighted, and I assume it's been highlighted by the parties and it's something that you all have and you can,
No, not the November 14th list hasn't been highlighted.
No, we don't have a highlighted November 14th.
Well, talking.
well, the earlier list should be the same other than the additions after November the 14th. So if you have some earlier highlighted list, do you have any list?
The only thing that's highlighted are the objections in yellow. So all you have to do is go down the objection line and see where it says
Oh.
objection,
Okay.
I see, okay.
and you can highlight
That's all
yourself.
the objections, Judge, that's highlighted to you. That doesn't
Right.
help you.
Well, it does because we'll just go through, I'm going to number the pages as we go through them since they're not numbered. And I want you to indicate to me those things that are subject to argument rather than just preserving the record. So on page 1, what is there that you want to preserve the record or that you want to argue? Not just preserving the record.
I think the first one is 20. Our position is that diagram is inaccurate. And I think it was virtually conceded that it was.
The inaccuracy, which has been corrected in front of the juries, is that the coffee table in the diagram is at a more acute angle towards the sofa than actually at the scene aside. And I think that's been made clear, and I could make it clear again when Detective Zeller testifies. But in terms of everything else, it is accurate, and I think that it is the only diagram we have of the particular crime scene.
I think it also is not to scale. I think it's more confusing than illustrative at this point.
No,
because it isn't fixed.
I think Detective Zeller can testify it is to scale. We have the measurements, and
Why don't the people just do a new diagram and substitute?
All right, if this has been referred to during the testimony and if there's a foundation established that it is to scale and it's been clarified already regarding the positioning of a certain object, the objection is overruled. Anything else on the first page?
No.
All right, then everything on the first page will be received
No.
with 20 will be received unless there's a further objection by the defense based upon the further testimony of Detective Zeller. What?
12 is withdrawn, Your Honor.
Yeah, those, with those things being offered are received except for those things that have been withdrawn. It's listed on the list here, so we don't have to go through it.
Okay, so is the court going to mark a copy of the list as an exhibit so
Does
that,
the clerk have a copy of this list? Okay, well, here's
well,
November 14th.
and I have the new.
I have another one.
Okay, I've given her the November the 14th list.
And I have the updates.
Okay. Everything on that sheet that is being offered is received. Those things that are being withdrawn are not being received. Those things that are not being offered are not being received. So it's
Very much. It might just be easier, Your Honor, and just to indicate the numbers of the things that are withdrawn on each page. There aren't that many, and it can make it easier for the clerk ultimately.
All right, if you want to do that real quickly, as we find them, Exhibit 12 was withdrawn. Everything else is being received. All right, and on second page, we'll number that page 2.
Your Honor, I believe we have objections to litigate to items 44 through 48. And then on, in item 53. Actually, and as to Lyle Menendez, 54 and 55.
Those are real objections or for the record? No,
Those are incorporating prior arguments.
Okay, these are not anything new that you wanted to add. These are just objections that have previously been made. Is that right?
So 44 through 48 are real objections. 53 is a real objection. The others are to preserve the record.
Okay, and 44 through 48. Did you want to argue that?
Well, I think 47 and 48 were offered by the defense.
Yeah, you're objecting. We're assuming you mean it.
Right.
So let's go 44 through 46 then.
Okay, I think the court can recall with these things where this was a general educational diagram. It did not illustrate anything relevant or specific to the case or to the type of gun here or to the type of pellets. And we think it would be confusing and deceptive to the jury to see these patterns and make anything of them because they have nothing to do with the actual shooting in this case. And the same is true of the diagram of shotgun shell. It's not the type of shotgun shell that was used here. It's different and it looks different. The manual of Mossberg shotguns is full of hearsay.
Well, the manual itself is not going to be received. The objection to 44 and 45 is overruled. On 46, if the photograph, if you want to identify a photograph of the weapon that is most similar to the weapon in question, you can do that.
For that particular model.
Yeah,
Okay.
but the whole,
I don't think the whole manual's in, Your Honor. I think only Xerox certain page.
No, it's there.
well, I know you had the manual here and you also had Xerox of it. So you don't have to go through it now, but the objection is sustained at 46 with the understanding that you can modify it if it can be isolated to the gun in question. And then the people object to 47 and 48. Let's say 47 first.
Yeah, 47 was when Ms. Abramson took apart the shotgun shell with,
The diagram.
and I don't know what the relevancy of that is.
Well, that's an accurate example of what one of the shotgun shells in this case looked like as compared to the diagram above, which is not accurate to what the shotgun shells in the case looked like. The reason I did that was because I thought the 45 was so misleading. The jury should see what an actual shell like the one that could have been fired here looked like.
Then that's fine. I would withdraw the
All right,
objection.
as far as 47, my recollection is that there possibly is some powder as well that will have to be
I'll make sure
separated.
it's
And
separated.
only the paper casing and the plastic or whatever else was inside the cartridge or shell can be used as an exhibit. So it'll be received with a modification. And counsel will have to deal with that. As far as 48, it was offered as to Eric Menendez only.
Yes, we introduced it. There was testimony by
I
Craig.
recall what it is. What is it?
That is hearsay.
All right, it wasn't offered for the truth. It was offered to show Signorelli's conduct, use of some nomenclature, as I recall. It was an issue in his testimony in relationship to the defendant. Is that right?
Yes, Your Honor.
Can we wait till Mr. Kuriyama comes back, please? He's looking for the transcripts so that he can make his objection.
All right, we'll hold off since that relates to Mr. Kuriyama's case.
Your Honor, can we have a biological break?
Well, let's at least finish this page here.
All right,
53, 54, and 55 are
No,
objections.
53 is the only one, and the only objection there is that since they already have Exhibit 52, which the jury can look at. The blow up was purely for illustrative purposes during trial. There's no reason why they should have the blow up in the jury room. They already have the documents.
All right, that is a issue that has been testified to by all parties, both defense and prosecution witnesses. It's the shotgun purchase records,
That's a
and to assist the jury in looking at them, since it's an issue directly related to this, what's been produced by both sides. The objection is overruled. It's not a diagram or anything. It's just a photo enlargement of the
fine.
exhibit.
Then we'll object to 52. They don't need it both ways, I suppose. How many times?
Well, I don't see that the jury's going to be using them both. They'll use one or the other, and just for their convenience and deliberations, it seems to me proper to use them both. It'll be received. All right, what is 54 and 55? What is those, just to preserve the record? Or?
Yes.
Yes.
Okay, and that's only as to Lyle Menendez, so they'll be received.
There's nothing withdrawn on this page. Now.
Okay.
We're at the end of the page.
And then, again, on page 3,
61, Your Honor.
that's only as to Lyle Menendez.
No, I believe that came in as to both Eric and Lyle Menendez.
61 was
Okay, during the Lyle Menendez case, it was marked for his purpose only, and then during the rebuttal, strike that, during the defense case, it was brought out by the defense during the cross-examination of Goudreau during the People's case, and then during the defense case, you called Goudreau back, and it was shown to him at that point. Is that right?
No, Your Honor. Mrs. Bozanich asked Lyle Menendez about it on her cross-examination of him
Okay,
and referred to it specifically.
okay, and then you showed it to him at that point. That's right.
Yes.
Okay. What is the people's position regarding that?
The people's position is that this is this letter written to Mr. Goudreau should be excluded under 352 because it's an attempt by Mr. Menendez to portray himself in a good light right before Mr. Goudreau testified, and also that the contents of the letter are hearsay. So for both of those reasons, it should not be admitted.
Your Honor, it was referred to both times in this courtroom by the prosecution, not by the defense.
Oh, I don't believe that's correct. I think it was brought up by Ms. Lansing with Mr. Goudreau on his first appearance on the witness stand.
That is not correct. Ms. Bozanich asked him when he had last heard or if he'd received a letter, had some contact with him. He referred then to having received a letter from Lyle Menendez. And I think at that time, there was a stipulation entered. I can't remember for sure, there's discussion about a stipulation because my concern was whether this looked like this was some sort of a threatening letter. We then marked it. And then Mrs. Bozanich asked Lyle Menendez on her cross-examination, isn't it true you wrote a letter to Donovan Goudreau to try and portray yourself as a good guy? And Lyle Menendez's answer was, I am a good guy. So both references to this letter came from the prosecution.
But that doesn't make it the contents admissible.
Well, I think that now the jury may speculate in terms of whether there was any sort of negative communication there. And I think since they've brought it up twice, the jury has a right to see what it's all about.
Wasn't the letter read, portions of it read by the witness?
No,
I don't believe so.
no, Your Honor.
Seems to me it was. The contents came before the jury. It wasn't just the exhibit itself, but somehow it was referred to in the testimony.
No, Your Honor, I think what happened is that in order to avoid the idea that it was a threatening letter, that it was characterized as a favorable letter.
Yeah, that was during an earlier stage in the proceedings, but then during my recollection was it was during the examination of Mr. Goudreau when he was called back that somehow the defense read portions of it to Mr. Goudreau.
Okay, but can we?
You can research the record
Yeah.
on that one and make a determination as to if it's portions have been read, then those portions are already before the jury and it doesn't have to go to the jury. Let's first find out what happened. You can research that matter. What else on page 3?
There's
66.
65 and 66.
We have nothing to add to
Okay, those
previously made arguments with regard to any of the exhibits. The people have a few
Your Honor,
items.
I know does the court have some red ink on this page?
Yes.
All right. The Eric Menendez jury only for 68 and 69 is incorrect. Has that been corrected?
You've corrected that and made it Lyle Menendez.
It's the Lyle Menendez jury only.
Correct. Okay. Do you want me to argue those at this point? Those particular items were things that were shown to Mr. Witkin during his testimony, and
There's no foundation as to where they came from. It's
Exactly.
my recollection. They were just things that were somehow prepared, and we don't know what the source was.
That's correct. And then as to 70, which is in front of both juries, Mr. Witkin was cross-examined by me at page 89, 35, and 36, it looks like, where he said that this could be recreated at any time, that the timestamps in that particular brand of computer are unreliable, and therefore there's no way of knowing that that particular document was created in 1993 or in 1989.
Okay, there's no foundation as to either 68, 69, or 70.
But the problem is that he also testified that 70 looked like what he saw on the screen. And so in that sense, he authenticated the information and the setup of 70.
Well, he didn't have a clear recollection of every the detail of it. It looked similar, but there's no foundation as to where these things came from. I noted it at the time when they were marked. My notes, when I put them on my list, there's no foundation. Nothing has occurred since then, so
Oh, we have the,
objection is sustained to those. They will not be received. 68, 69, 70.
okay, 71 we did have an objection to.
Huh?
And that's the blow up. It's our position.
I don't see, is 71?
No.
Yes.
Okay.
It's our position that if there are records of these items, it unduly emphasizes them to have the enlarged version.
Yeah, in regards to this exhibit, I agree. It's not, it's just some corroborative evidence or circumstantial evidence. It's not the type of evidence that I referred to as relating to this purchase of the shotguns.
No, Your Honor, it has to do with the purchase of the.
I understand that.
Oh, okay, but
Yeah.
can I substitute the smaller copy on just an 8.5
Well,
by
don't you
11?
have a smaller one?
But it's not in evidence, so I'm asking permission to
Oh, I
substitute.
thought there was.
No,
This was money. It had to be done big.
Sure, you can substitute a smaller one, but
yeah, all it would be is just the credit. There's 3 credit card receipts and just on one page, and they're normal size.
okay, why don't you do that?
I will.
Also, so it doesn't burden the clerk in having to distribute these to the jurors. The blow-ups are nice as exhibits for argument and things of that nature, which you can use it for, but to give them to the jurors really doesn't prove anything, and it really is a burden on the clerk. So 71 will not be received, but may be substituted. All right, anything else on this page? Other than the pro forma objections?
No.
Your Honor, does the court copy indicate that the prosecution is withdrawing number 83?
I was going to read the list.
Yes.
The exhibits withdrawn on this page, Your Honor, are 62, 65, 67, 72, 73, 74, 82, and 83.
Yes.
Correct.
Okay, and then page 4. '84 was withdrawn.
Yes.
Any objections to any of these other people have objections to some, defense have objections to some, other than the pro forma objections or the, I don't want to mischaracterize them, the objections that were previously made. Any further objections to any of these exhibits?
Yes, Your
Your
Honor.
Honor,
I'm sorry, go ahead.
it's to number 96. That was not introduced in the prosecution's case in chief, and we would be objecting to it.
96 was marked for identification only,
Okay.
Your Honor,
time it was referred to.
Your Honor, I have to check Lyle Menendez's cross-examination. I was planning on reading this testimony this weekend. I'd like an opportunity to do that, to see if I used it during then. I think I may have. Otherwise, it was not used during the coroner's testimony, certainly. And then I'd like to point out at 94, which is the defense objects, That photograph was used by the defense.
First,
Yes.
only after, I think.
Well, I don't know if,
it was used, then it was used.
yeah, it was used at page 9222.
Negate any objection if it was used.
Mhm.
So it's hard to object to an exhibit that you've used in your examination of a witness. Well, I guess you do
Oh, no, it isn't. It's just hard to do it with a straight face.
successfully.
Yeah.
Any other arguments to relating to any of these other exhibits?
Yeah, I'd like to take another look at 98 and 99, Your Honor, to see if they can be properly redacted, because I think it's important for the jury to understand just how
Sure,
busy.
those are Oziel's appointment
Right,
books.
exactly.
Yeah, you certainly can do that. Why don't you go through here and indicate those things that have been withdrawn?
Okay, on this page, withdrawn was, I can say 84, 98, well, that's what I want to discuss, 98 and 99, 100. That's it. Now, there are real objections. I hate to use that word, but I mean, litigatable. I guess the prosecutions are seriously objecting to.
103 through 106.
Okay.
What about 101?
Yes.
Okay, so they're 101 through 106.
Yes, that's correct.
Okay. And 108 through 110. Are you still objecting to his CV?
Okay.
It's
And 112, you're still objecting to that? These are all things that were,
I'm trying to remember 112 letter for Judelance. Oh, that was the letter that was written.
that's his
That
fake
was
letter,
the-
diagnostic letter.
Right.
She testified about that.
So did he?
Right.
She did, so,
Yes, she did.
too.
okay.
All right. As to 101, well, 101 is different from the others. People's objection is that it's irrelevant that she signed this agreement.
Well, what was relevant about the reason it was brought in is because it was fraud by Dr. Oziel. She hadn't met him as of June 1st, and she's testified to that, and he was
Okay,
cross-examined.
101 will be received since it's been referred to during the testimony and relates to also potentially the testimony of Oziel as to documents that he felt could be uncovered by the defense with
Right.
her name on it.
That was during the 1538.5.
No, I think it was during his testimony as well.
No, he said that too, yeah.
All right, 102.
102 through 106 are a series of correspondences with Dr. Oziel after the case was filed in which they were trying to get information from him, and it's his responses to them. And it would be the people's objection that the communications between Dr. Oziel and counsel are irrelevant and contain hearsay material. And I'm not entirely sure if this was in a 402 or if it was in front of the jury.
This was in front of the jury because Dr. Oziel was coming up with new stuff and claimed that nobody had asked him about things before. And so we presented him with these very detailed requests for information that had been given to him, and his response to that, which is that he had no additional information, in order to impeach his credibility on all this new stuff he was now testifying to.
I think he also testified that his responses were on advice of counsel.
No, I think he said he didn't have, he did say he didn't have anything else, that's all.
Does the court recall these particular exhibits?
Yes, I
Whether-
do. I
okay.
have my notes here, and I've already written a note at the time that as far as 106 is concerned, I regarded it as relevant evidence. And if I regarded it then as such, I regard it now as such. So 106 is not going to be received. As far as 102, 3, 4, and 5, that just relates to the ongoing efforts by the defense to obtain information from Dr. Oziel. It was all part of his testimony in relationship to what he could or could not disclose, and the prosecution's objection is overruled and they'll be received. The only caveat would be if there was any doubt in anyone's mind that this was introduced before the jury, you can review 101 through 105 are,
Your Honor, I need to take a look at 106 again. Does it make any sense to allow that in and then keep out 106, which is his basic stonewall in response?
well, if you take that position, then we can
Yes, we could,
sustain
but
the
I'd
objection
rather
to
we went the
101
other
through
way.
105.
Well, can we look at 106 and just make a
Certainly.
note to revisit
Yeah,
this?
but at the time I viewed it, I had formed that opinion. I don't think anything is going to change at this point, quite frankly. Anything else on this page?
Yes, 108.
Well, these are the people, why don't we have the people
Yeah.
indicate what their serious objections, even though we suspect it.
Well, the accusation by the Board of Psychology contains a number of accusations, and the people would object to those as being hearsay, and they're
Right.
certainly inflammatory.
All right, that is sustained. It's just an accusation. It's been referred to and won't be received.
I believe Exhibit 109 has been sealed.
Yeah, it's not received.
The reason we object to this Dr. Oziel's CV at 110 is because he was not offered as an expert witness.
Oh, but it definitely was.
Well, he was
tested.
examined on it and it'll be received.
But there's been no testimony of it.
All right, anything else on page, this 112 was
I think that was the letter that was written for her to keep her out of court.
okay, it'll be received.
Okay.
All right, and 84 was withdrawn, and I think you indicated that
And
98, 99, 100 has been withdrawn.
right, 98, 99 well in review, 100 was withdrawn. We'd like to be able to make perhaps a substitute for 98 and 99.
All right, page 5. All right, there are some question marks near the top of,
Yes, Your Honor. I think that the problem with the boarding pass was the lack of authenticity, and I believe that was objections withdrawn to 116.
okay, 116 will be received, 115.
Your Honor, those were documents that were prepared by people with Dr. Oziel's consent regarding a press conference he had. And to that extent, they would be hearsay and also irrelevant. I think he testified that he had had a press conference. I don't think the documents are competent evidence of that.
You said they were or were not prepared with his consent?
They were.
Okay, they'll be received. All right. Then we have a series of audio tapes.
Yeah.
There's a whole series of audio tapes, not just here, but elsewhere. And I think we have to deal with them all together. And also, Mr. Burt, regardless of whether these are received, specifically, you indicated that you would supply the court with redacted. In the trial of People versus Lyle Menendez, he is in court with his attorneys, and the people are represented. And the court did receive a note this morning from the jury. And counsel have been provided with a copy of the note. I'll read it into the record. It states, we regret to inform the court that we are unable to come to a unanimous decision on any of the 3 counts. We are open to any suggestions or direction the court may have which would enable us to come to a decision. And it's dated today's date and signed by the foreman. The court intends to have the jury come out, and I'll make further inquiry of the jury in regards to their status. Did counsel wish to be heard as to the specifics of that inquiry?
Your Honor, we have several thoughts in this regard. Based on the questioning of the jurors yesterday, it's apparent that a number of them have suffered considerable damage as a result of the earthquake and expressed some concerns with regard to being available to take care of their own personal needs. One juror in particular had asked for Wednesday and Thursday.
And the court did indicate that the court would accommodate them.
Correct. It would be our request that in addition to giving an admonition similar to the one that the court gave to the Eric Menendez jury, that the court consider recessing the deliberations until next Monday so that these jurors could take care of whatever their personal needs are without having the conflict of being here trying to deliberate and also being concerned about their own situations, which are extreme in some cases. I think it is not coincidental that this jury, which has been working for a long time, never indicating that they couldn't reach a verdict, does so almost immediately upon coming back to begin deliberations following the earthquake. So those would be our requests, would be that there would be an admonition similar to the one given to the Eric Menendez jury, and that the deliberations be recessed until Monday.
So you're requesting the court give the admonition that the court gave to the Eric Menendez jury that is set forth in the case of People versus Gaynor at 19 Cal 3rd, 856.
That's correct.
What is the people's position?
Sorry, what'd you say?
The people would also request that the court give that instruction.
What I will do is make inquiry, as I said, of the jurors and ascertain what their situation is. In regard to the request to put the matter over until Monday, discontinue deliberations now and resume on Monday, the court did inquire of the jury regarding their situation. We did that individually yesterday in a closed setting so that the jurors could feel free to inform the court of any problems they've encountered because of the earthquake, personal problems, anything of that sort. And they did so. They gave us detailed information about the situation they had encountered as a result of the earthquake, their personal problems, some of which were substantial, others much less so. And the court indicated that it would provide time for the jurors to deal with those matters that the jurors needed to deal with. So that has been covered to a great extent already. All the jurors indicated that they could continue their deliberations as of yesterday and would be able to continue today, and that the earthquake and its aftermath and the effect on them, none of that would have any influence on their continuing their deliberations. So I think the area has been covered, but I'll certainly explore it further with them if their response indicates that it is such that further inquiry is necessary. What I propose to do is deal with this a little differently than with the Eric Menendez jury, in that this jury has been out longer than that jury, and depending on the nature of the response of the foreman, I might make some further inquiry of the jurors individually at this point as to their evaluation of whether or not there's a reasonable probability of obtaining a verdict at this point, and then proceed with instruction, if appropriate, on along the line of the instruction I gave the Eric Menendez jury. But I'll consult with counsel further if the responses are such that I intend to go in a different direction. All right, so let's have the jury and the alternate in, please. Summoned all the parties here so that I can now speak with you about your note. Just to read it again to you so that you all have a understanding of what the note says. Quote, "We regret to inform the court that we are unable to come to a unanimous decision on any of these three counts. we are open to any suggestion or direction the court may have which would enable us to come to a decision, end quote. I assume when the foreman wrote that note to me, that was a reflection of the consensus of the jurors. Is that correct? Right. All right. Let me say that you certainly have been deliberating for a substantial period of time, and from my observations, you've been very diligent in your deliberations. Although the foreman indicates that he feels that the jury is unable to reach a unanimous verdict on any count, I want to ask you whether any of you feel that the court can provide any assistance by way of further instructions on the law. I know there have been instructions already that you've asked for clarification about, whether anything further along those lines would be of assistance to you in reaching a decision, a unanimous decision as to any of the three counts. Whether there's any further readback of testimony of any witness or any part of a witness's testimony that you feel would be of assistance to you in reaching a unanimous decision on any count. When the foreman asks for suggestions or directions of the court, that's basically what my response to you as to whether or not you feel further instructions on the law or reading of testimony would be of any assistance to the jury in reaching a unanimous decision. And what I ultimately will be asked to determine is whether or not there's a reasonable probability that the jury can reach a unanimous decision on any of the three counts. And I assume you've discussed this among yourselves as to whether you feel there's a probability of reaching a verdict. But what I want to do is ask now of the foreman whether you feel that, number one, any further instructions on the law or reading of testimony would be any of assistance in the jury continuing its deliberations with the idea that the jury would have a reasonable probability of reaching a unanimous verdict.
I really don't think so. I really don't.
Does anybody else on the jury feel that further reading of testimony or further instructions on the law would assist the jury in reaching a verdict in this case?
The gap is too wide here.
Okay, well, let me ask you individually here, one at a time, and I'll just go through you as you're seated in the box. I won't read off your names, but just go through, starting with juror number one and going through, asking whether or not any of you feel there's a reasonable probability of reaching a verdict in this case. Starting with juror number one. Juror number two. Number three. Number four.
No.
Number five.
No.
Number six.
No.
Number seven. Number 8. Number 9. Number 10.
No.
Number 11. Number 12. Do any of you feel, any of the 12 of you feel that further reading of testimony or instructions would assist you in any way? If you do, would you answer yes?
I have, as far as the law.
Okay, without going into the specifics of what the law is there something that you feel would be of assistance to you and the other jurors in reaching a unanimous decision?
I think the understanding of the law is the problem that we have.
Okay, on a specific subject of the law or area of the law? Okay, have you tried already to ask that question of the court in regard to that particular question?
But there's other areas of the law as far as.
Well, have you put that in writing as far as the problem that you're having and asked for the court to clarify it?
Just one
One part of it? Is that right?
Yes.
Okay. Is there something else that you feel that the court could do in answering something else that would clarify the issue?
Maybe for me, but maybe not for the rest.
All right. First of all, do any of the others of you, other 11 jurors, feel that way, that the court could clarify anything on the law that would assist the jury in reaching a verdict in this case?
There may be a couple of instructions that we could clarify. However, I don't think that it would enable us to come to a unanimous decision. There's a couple of interpretations of one or two of the instructions. However, even if we were to settle those small matters, I don't think it would make a difference in terms of coming to a decision on a particular count.
What I'm going to do is, since there is some disagreement, even though the end result might very well be the same from what I am hearing here, I don't know if it would or not, is do this. Ask that you go back into the jury room and discuss this particular subject of whether there is any clarification of the instructions that would be of assistance in the jury reaching a verdict that all 12 jurors can agree to. And if there is a reasonable probability in your mind that the jury could reach a verdict, then you should continue your deliberations and request that there be that clarification. If you don't believe that there is any reasonable probability of obtaining a verdict, then you should notify me in writing of that fact. And you don't have to wait a long time to do that. You can do that if you come to that understanding fairly quickly. If it takes you a while, then certainly take as much time as you need to resolve that issue. And let me remind you that you should not disclose any numerical breakdown of your vote unless I specifically tell you to do otherwise. Let me ask you this as well. We went through this inquiry yesterday. Several of you sustained property damage at your homes and dislocation because of the earthquake. And we all want to determine whether or not the earthquake, its aftermath, is having any impact on the position you're now stating, that you are in this position where you can't form a unanimous decision. Do any of you feel that the pressure of that event or the aftermath and the pressure on your personal lives is causing you to come to this belief that you can't reach a unanimous decision?
No.
Okay. All right, then what I'm going to do is send you back with the idea of telling me whether or not you feel there is a reasonable probability of reaching a unanimous verdict as to any count. And let me remind you that the verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree to it, and your verdict must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your views and change your opinion if convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. All right, what I'll do then is ask that you go back, consult among yourselves, and let me know whether you feel there's any reasonable probability of reaching a decision. And if you feel that there is, then continue your deliberations, ask for clarification on the law. If you feel there is no reasonable probability, let us know that, okay? The jury and the alternate are now in the courtroom, and I did receive the note this morning which reads, "We deeply regret to inform the court that we are still unable to reach unanimous decisions on any of the 3 counts or lesser charges. I assume from the note that the jury has discussed the issue in depth. Is that correct? As far as whether the jury can reach a unanimous decision? All right. And is it the position of the foreman that, or let me ask you this way, do you feel there is any reasonable probability that the jury can reach a unanimous decision as to any of the 3 counts and any of the charges? Do any of the jurors feel there's any reasonable probability of reaching a unanimous decision as to either of the 3 counts, or any of the 3 counts, or any of the charges in those 3 counts? Does anyone feel there's a reasonable probability of reaching a unanimous decision?
No.
Is that all 12 of you agree that there cannot be a unanimous decision?
Yes.
Okay. Does anyone disagree with that?
No.
Okay. Do counsel wish to be heard?
No, Your Honor. No, Your Honor.
All right. The court finds that there is no reasonable probability of the jury reaching a unanimous decision in this case, based upon what has been stated by the jury and all of the individual jurors. The court did submit to the jury foreman a request to come up with a numerical breakdown of your voting, at least as to the last vote. Have you done that? All right. Did you put that in writing, or did you? Okay. Could you give that to the bailiff, please?
Just that.
And the verdict forms as well. I assume the verdict forms are unsigned. Is that correct? And the list that you've prepared of the numerical breakdown, is this a reflection of the last vote that the jury took? And has there been much change during the course of your deliberations between the beginning and what it is now?
There had been some, but on balance, that's a pretty accurate reflection of what we've come to over time.
All right. And all right, the court, in reviewing this numerical breakdown, finds, in addition to the remarks of the jury and the jury foreman, that there is no reasonable probability of the jury reaching a unanimous verdict in this case as to any count or any charge. Therefore, I find that the jury is hopelessly deadlocked, and the court declares a mistrial in this matter. And the jury is therefore discharged from further participation in this case. I want to thank all of you for all the time and effort you've put into this. You've been here a long time during the trial itself, during the testimony. There have been a lot of delays. We've imposed upon you throughout the proceeding by having you come in and wait and then tell you to come back at another time. And the trial has taken a lot longer than was anticipated. And I know that by itself was a great inconvenience for you. And since the deliberations have begun, many of you have suffered yourselves because of the earthquake and its aftermath, the personal losses that you've sustained, property damage and dislocation. And I know that's a great ordeal that each of you, or many of you, have to deal with. And we sympathize with you and hope very much that you can get on with your lives and get things back together in that regard. The system of criminal justice cannot function without jurors willing to serve, and without people such as you willing to serve as jurors. And we appreciate very much the time and effort you've put into the role of jurors in this case. Let me give you a little information regarding what will happen now that the jury has been discharged, so that you know what is ahead of you for the balance of the day and what procedures will apply. The lawyers often want to talk to jurors after the case has been completed to get more insight and information about your thoughts about what happened during the trial, about your evaluation of the case. It helps them in reviewing the matter. And if you are inclined to talk with them, we'll make the courtroom available for that purpose in a few moments. It's up to you whether you want to talk to the lawyers. Some jurors feel they don't want to talk to anyone after the trial is over, and that's your choice. Some jurors are more than happy to talk to the lawyers and anyone else about the case after the trial is completed. And again, that is your choice. We will make the courtroom available, however, for that purpose in a few moments. We'll clear the courtroom, and then you can speak with the lawyers, those of you who wish to do so. Also, you might or might not want to discuss this case with other people other than the lawyers once you are excused. That, again, is your choice. You don't have to speak with anyone at all about this case. You can speak with everyone about it if you choose. It's up to you. What we will do, however, is make the courtroom available for you if you choose to speak with the news media and you want to have a controlled situation for that purpose. Again, you don't have to talk to the news media at all. You can just go about your business and never speak to anyone about this. But if you want to speak to the news media, we'll make the courtroom available for that purpose. We'll have public information officers here to conduct a session where you will be able to speak with the news media. They can ask questions of you if you choose. You don't have to do that either. If you want to leave, that is your choice. I'm not suggesting that you speak with anyone. I'm just telling you these are the options. And in order to make things easier for you, we'll make the courtroom available for that purpose. Your names were used during the jury selection process, so your names are known, and it's not unreasonable to expect that somewhere down the line, some people from the news media might try to contact you once you leave the courtroom. So to make that a little less onerous for you, or to make that situation a little more tolerable, we make the courtroom available for you to speak with the news media if you choose to do so. And we will do the same with the other jury that was excused, the jury for the other defendant. Regarding personal identifying information that was provided by you when you were summoned as jurors in this case, the law provides that if you wish to request, the court may seal that personal identifying information. And we have forms for you to make such a request. As I said, your names are already known because they were used during your names were used during the jury selection process, and some personal information about you came out during the jury selection process because, as I said, portions of your jury questionnaires were made available to the public during that process. So some information about you is already in the public domain, and that is part of the trial process. But if there's other information which you feel you want to keep confidential, the personal identifying information, we have a form for you to fill out. We also have the jury clerk here to assist you in checking out as jurors so that once that paperwork is completed, you'll be able to leave as soon as you wish. That is basically all I have to say. Again, my thanks to all of you. And what I'm going to do is ask that you go back to the jury room right over here just for a few moments until we get things organized, and then you can speak with the lawyers if you choose to do so. If you don't, as I said, you don't have to, and then we'll have the other process. For those of you who wish to speak with the news media, we'll have that available in the courtroom as well. So one last time, we'll ask you to go back to the jury room, and with our thanks. All right, the jurors have left, and for the availability of counsel, I'll read off the jury vote here, the last tally. And I'll also read off the tally for the Eric Menendez jury. For count 1, which was the count relating to Jose Menendez, the jury vote was 3 votes for first-degree murder, 3 votes for second-degree murder, 6 votes for manslaughter. It says manslaughter, but I assume it's voluntary manslaughter. 0 votes for involuntary manslaughter. Count 2 relating to Mary Louise Menendez. Count 1, 3 votes for first-degree murder, 3 votes for second-degree murder, 5 votes for voluntary manslaughter, 1 vote for involuntary manslaughter. Count 3, the count of conspiracy, 3 votes for first-degree murder, 3 for second, and 6 for not guilty. For the Eric Menendez jury that was previously discharged, the vote from that jury as provided by the foreman at the time the jury was discharged is as follows. For count 1 involving Jose Menendez, the Eric Menendez jury final vote was 5 votes for first-degree murder, 1 vote for second-degree murder, 6 votes for voluntary manslaughter. Count 2 involving Mary Louise Menendez, the Eric Menendez jury voted the last vote, 5 votes for first-degree murder, 3 votes for second-degree murder, and 4 votes for voluntary manslaughter. And count 3, the final vote in regard to the conspiracy count was 5 for first-degree murder, 1 for second-degree murder, 6 not guilty. All right, that is the information regarding the numerical breakdown for both juries. Regarding further proceedings in this matter, the co-defendant's case was put over to February the 28th for trial setting, day 0 of 60. Is that an agreeable date?
It is, Your Honor.
Okay. Lyle Menendez, you have a right to a trial within 60 days of today's date. You give up that right and agree that your trial will be within 60 days of February the 28th.
Yes.
Counsel joint?
Joint.
All right, then this case is continued to February the 28th, 9 a.m., Department N in this courthouse. And that completes this hearing. And we'll now clear the courtroom, please.